One can question what purpose does a medical malpractice lawsuit serve to society? In theory, the law says deterrence. Once you bring something to the forefront and people become aware, they are not going to do it again. In reality, it's a message to the medical profession. I have many conversations with physicians in which they tell me, I learn more from a legal case of what not to do than what I was taught when I was a resident. Physicians are not bad individuals. Physicians commit errors when they take shortcuts or when they forget to take some precautions. So reminding them of what should be done, and if you don't do it, you are subject to litigation, improves the medical care. The public hears a lot of times that frivolous lawsuits increase the cost of medicine. The total cost of medical malpractice is less than 0.5%. No lawyer that is familiar with what it takes to evaluate a case, prepare a case, and try a medical malpractice case will ever get involved in frivolous lawsuits.
Every day, somewhere in America, more than 300 innocent men, women, and children become victims of medical malpractice at the hands of incompetent and negligent doctors. Last year, over 98,000 victims were killed by doctors. More than 4 million victims are permanently injured each year. Today, the Insider Exclusive goes behind the headlines in When Doctors Go Wrong, Kim Matsuyama's story, to examine how Dr. Max Borton and Sid Gorovitz, partner at Gorovitz and Borton, got justice for Kim Matsuyama's family in a landmark Massachusetts medical malpractice case. Dr. Max Borton, a board-certified obstetrician gynecologist and trial lawyer, and Sid Gorovitz have built their reputations based on aggressive and creative trial work. They have obtained numerous multi-million-dollar verdicts and settlements for clients who have been involved in traumatic situations which altered their lives physically, mentally, and financially. And it has earned them the highest respect from citizens and lawyers alike as some of the best trial lawyers in Massachusetts and in the nation. They have seen many innocent and hardworking people injured and killed by negligent and incompetent doctors, hospitals, and nurses. Their passion is problem solving. They approach each medical negligence case as scientists and lawyers trying to solve a puzzle. And because they've seen many patients suffer needless injury, they make it their dedicated mission to change the laws for the benefit of all medical patients, as they did in this landmark Massachusetts Supreme Court case, because they believe that all patients are entitled to receive care and treatment consistent with their expectation of finding a cure or having a better quality of life. Their loss of chance, essentially loss of chance of a more favorable outcome either by cure, longevity, or quality of life in the event of negligence of the medical provider, should not be ignored or denied just because the negligence was not more than 50% responsible for the damages suffered by the patient. The patient should not be at risk because the doctor hides behind the defense that more likely than not, that patient would have died of the disease in any event. Quality medical care should be provided to all patients regardless of the percentage of injury, illness, or disease already suffered by the patient. The loss of chance doctrine views a patient's prospects for surviving a serious medical condition as something of value, even if the possibility of recovery was less than even, which was the prior law in Massachusetts, prior to the physician's negligent conduct. Successful recovery is now permitted in many instances where previously such recovery would have been denied in Massachusetts in total. Establishment of the loss of chance doctrine serves to fairly compensate the patient for having been wrongfully deprived of an opportunity to live longer or have a better quality of life even though the patient had less than a 50% chance of survival at the time of the physician's negligence. Whereas the negligent medical provider was previously able to hide behind the literal blanket release from liability if the patient had less than 50% chance of survival, that same medical provider is now held answerable, accountable, and responsible for that patient's loss of chance of survival. And through the American judicial process, they get answers to these tough questions, which results in hospitals, nurses, and doctors being more responsible to patients and society. Their successes drive them to help more people who have been harmed by incompetent and negligent doctors. Their goal? To make medicine safer and more accountable, and of course, to get justice their clients deserve. This is the Insider Exclusive, live from Waltham, right outside Boston, Massachusetts. It is my great pleasure to introduce Max Borton and Sydney Gorovitz to the show. Welcome to the show, guys.
Thank you. Thanks for having us.
Tell our audience a little bit about your firm. You specialize in medical malpractice, correct?
Correct.
And
we're a very unique law firm. Unique in the sense that our entire practice is specific to representing people who've been harmed, injured as a result of medical malpractice. And what we bring to the table that really differentiates us from other firms that are doing malpractice is the fact that my partner, Dr. Max Borton, was in the hospital, in surgery, operating for over 30 years. Board certified OBGYN. He was an assistant professor at the Harvard Medical School. He also taught at Suffolk Law School.
right.
He is a very experienced trial lawyer. I've been a trial lawyer for over 40 years. And when a case comes to us, we are able to look at this case, to assess it, parse it, evaluate it, not only from the legal point of view, but also from the point of view of the medicine.
Yeah.
What happened? What should have happened? Where did this practitioner go wrong? What outcome happened as a result of that?
Right. On this show, we are going to be discussing a landmark decision in the Kim Matsuyama case. It deals with a principle which is very important, and you, as a matter of prosecuting this case, representing your client and their family, changed the law. Please tell our audience what the law was before, and then tell us how it changed and about the case.
What essentially the law was before is what the law is now. And that is that you have to prove a case more likely than not. Probability, more than 50%. What used to happen before is that if you could not gather damages that were more than 50%, the case didn't exist.
So in essence, if a patient walked into a doctor's office in the Commonwealth and he had already existing medical condition which would be more than 50% responsible for his demise, whatever that doctor did to him, he couldn't sue them.
No, just the other way around.
Mm-hmm.
Take the case in the Matsuyama case,
Yes.
where it was a gastric cancer. Gastric cancers are usually discovered a little later than other cancers. But in cancers that are, for instance, stage 2, the chances of survival are between 25 and 50%. That's less than 50%.
Yes.
That case, in theory, should not have been prosecuted or should not have been filed. We filed it anyway. We prevailed at trial, and when they appealed, the defense appealed it, claiming that the chances of Mr. Matsuyama to survive were less than 50%. As a matter of fact, the jury decided it was 37.5%.
Right. At the time of the diagnosis.
At the time of the diagnosis.
Yes.
They appealed it, and they were so sure that they were going to prevail that they said, we'll bypass the appellate court, we want the Supreme Court to listen to this case directly.
Yeah.
And the Supreme Court took it on.
Mm-hmm.
And for reasons that are very explicit in the decision in the Matsuyama case, the court decided that without changing the law of medical malpractice, what they were changing is that you don't have to have damages that exceed 50%. That you can have damages in the 40%, 30% range. They didn't even give a minimal number, but you should be entitled to recover. Let me give you, for instance.
Damages by the last physician.
Damages by whoever was responsible in not diagnosing it at the stage where you had a better chance of surviving.
Yeah.
A patient that goes to a doctor, and let's assume that patient has 1/3 chance of surviving the condition they have.
Yeah.
And what I said to the Supreme Court was, behind the doctor there are 3 doors. 2 are locked and 1 is open. 1/3. What would the patient have chosen? Every patient would have chosen to go through the open door, the survival. The physician has no right to lock the 3rd door, take away that chance from the patient. And the Supreme Court understood and very clearly explained in the reasoning that every patient deserves whatever chance they have at the time they see the doctor. And if the doctor is responsible for taking away whatever portion of that chance, that's what they are responsible for. And that's where the case lost chance. It's not a new theory. Many states have adopted it.
Yeah, most states follow that rationale.
There's more than 50% at this point.
There is more than 50%. But some states have adopted that, and the legislature, the elected officials, have overturned that decision by creating a law saying there is no lost chance. But the majority of states understand that patients are entitled to proper care no matter at what stage of their disease they are.
Yeah, and at the time prior to you representing Mr.
Matsuyama.
Yeah, Matsuyama.
Well, his estate.
Yeah, his estate. There was, in effect, what was called the all or nothing rule, right?
That's correct. It was, if it's less than 50%, you get nothing. If it's more than 50%, you get 100%.
Has there been any efforts by any legislators to try and enact legislation overturning this?
Every year.
Every year?
Every year there have been bills in the legislature trying to overturn it, and they have not mastered the necessary votes to overturn it.
Since your primary focus is on medical malpractice, how do you evaluate a medical malpractice case? I'm sure people call you all the time and said, I was harmed by my doctor. What do you look for when you evaluate it, considering that you are not only a doctor, but also a lawyer, and you are also an experienced trial lawyer?
I think Max will explain it to you from the medical point of view, and I'll explain it to you from the litigation side.
The first and most important thing is gather all the medical records.
Yeah. And that's sometimes difficult to get, though, isn't it?
Sometimes it's difficult, but we can get them.
As a patient, if they're my records, can I demand them?
The law says you are entitled to the information that is in your record.
What does that mean?
What that means is that the hospital can charge you per page
to make the actual record.
That's correct.
Okay.
A physician's office can charge you for the record.
What do they charge?
Some people charge exorbitant amounts, some people charge nominal amounts.
Yeah.
That's not the problem. What's happening is that when patients get medical records, the institution or the physician's office usually provides them with the medical information necessary for subsequent care. That is not the complete medical record. What our office gets is usually what's called a certified and complete copy, meaning every page of the medical record has to be provided.
Yeah.
Everybody knows the deck of cards. Everybody plays with the same information. That's expensive.
Yeah, and that has the doctor and nurse's notes, correct?
As everybody's notes.
Everybody's.
And that's what they try to avoid, the average everyday patient, correct?
Well, I don't know.
Yeah.
I'm not going to second guess
Yeah.
what they are trying to avoid.
Let's just say that there's a major difference between what a patient, a client, prospective client, walks in with from the hospital
Yeah.
in
And what
terms
you
of
get.
size, and then 2 months later,
Yeah.
what we receive, which is the certified copy, the complete medical record.
So once you get the records, what are the 3 key areas you look for to decide whether you want to take the case or not?
Well, first you look at, has the patient or the individual been injured?
Mm-hmm.
Are there any damages? No harm, no foul.
Yeah.
So you look at that. Second, you look at what was the condition the patient presented to the physician. And then you go at what is usually known as the standard of care, what the reasonable and prudent physician would have done under similar circumstances.
Right. And that, and you being a physician, that you can offer a lot of insight in that.
That's where I do the first analysis. That's what we call the smell test. You know, if it passes the smell test, then we try to focus in on to what the actual departure was, and we have to find out if the departure caused the injury. Sometimes the injury happens for other reasons.
Right.
You can't hold the physician responsible for an injury that he or she could not have prevented.
And at the same time, I know Max will explain, there's a thing called known, K-N-O-W-N, complications of a procedure or a surgery.
But when you deal with the complication that is known to the community, to the medical community, you also have to find out if there were ways of preventing that from happening.
Not every injury is a compensable injury that occurs. Not every poor outcome that a patient experiences in a hospital from a provider is what we call a compensable injury, something that is worthy of taking forward as a medical malpractice. And that's where the second part comes in. We now look at the legal side of it, whether or not it satisfies the criteria that we need, and then we make an overview valuation. We try to also assess the person who's sitting in front of us. We try to project them forward. How will they fare in a deposition? If the case doesn't resolve, how will they fare in a courtroom? Are they the type of person? And this is very early on.
How can you know
Sometimes you get a feeling for it. Sometimes a person is so worthy of it, it doesn't matter what they look like, how they sound or anything. But the secrets that they have, we know are going to be found out by the defense counsel representing the malpractice insurance carrier. The slightest little scar, whatever it happens to be, they're going to explode it. So we don't want to be surprised 4 years down the line, 5 years down the line, as we're getting ready for trial. We try to identify as much as we can, as early in the process as we can.
Right.
Perhaps to give you a flavor, we have X number of phone calls, of which we have a lesser amount of requests for medical records, of which we have a lesser amount of cases we undertake to represent. When you add them all up, for every 25 to 30 initial inquiries, we may accept one case.
Medical malpractice is horrifically expensive to try in terms of our hourlies, how many hours it takes over the course of 4 to 5 years. We estimate it's approximately $400 to 500 hours of our time.
Yeah.
And it's a tremendous financial investment in terms of processing these cases, getting the experts online early on for the tribunal, for deposition, and then for trial. And most of our representations are on a contingent fee arrangement. Right. These people cannot afford to pay anything for us. So we only get compensated at the end if in fact we're successful.
Yeah, yeah.
So how many 400 or 500 hourly blocks of time do you have in your professional life that you can dedicate to the concerns of a particular person coming through the front door? How many $50,000 to $100,000 investments can you make on behalf? So we have to be very careful and very diligent in assessing the quality of a case for our representation, at least in this law firm, to carry forward with all of our resources, all of our efforts.
Well, this case that we've discussed today, the Kim Matsuyama case, was a landmark case. Yes. I'm glad you handled the case. I didn't realize every year you have to fight the legislature. And thank you very much for being on the program. This has been a remarkable case, and it has been a great honor and great work.
Thank you.
Thank you for having us.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.